Good afternoon, everyone. Welcome to the Assembly Committee on Commerce and Labor. Madam Secretary, please call the roll.
Assemblywoman Carlton. I'm here. Assemblywoman Considine. Present. Assemblywoman Dickman. Here. Assemblywoman Duran.
Here.
Assemblyman Flores. Assemblyman Frierson.
Here.
Assemblywoman Hardy. Here. Assemblywoman Kasama. Here. Assemblywoman Martinez. Present. Assemblywoman Marzola. Here. Assemblyman O'Neill.
Here.
Assemblywoman Tolles.
Here.
Chair Howdigi.
Present. And please note that we do have Assemblywoman Duran with us. She is joining us virtually today from her on the Zoom screen, and Assemblyman Flores is presenting in the Senate, so please mark him present when he arrives. Good afternoon, everyone, members, those here in person in the audience and those listening online. We have a pretty packed agenda of a work session and bill hearings. We're going to jump right into our work session. I think everyone's familiar with our housekeeping items. I am going to be taking the work session out of order. Two of the bills. We have some of the bill sponsors here in case anyone has questions and they need to get down to their committee for work session, so we will be taking them first. Just so that the committee is aware, we are going to take Senate Bill 196 and Senate Bill 290, and then followed by Senate Bill 209 on work session first, and then we will go back to the work session document and take them in the order of the work session document. So members, let's go ahead and jump right into it. I'm going to hand the mic over to my policy analyst, Ms. Pasloff-Thomas, to walk us through Senate Bill 196.
Thank you, Madam Chair. Senate Bill 196 prohibits the performance of a pelvic examination in certain circumstances. It is sponsored by Senator Lang, and it was heard on May 3rd. There is one proposed amendment by the sponsor, and that is to add Assemblywoman Tolles and Assemblywoman Dickman as sponsors.
Thank you. Members, any discussion on the bill and amendment before you? Assemblymember Tolles.
Thank you, Chair, and I just wanted to thank the sponsor for bringing forward this bill, for accepting additional co-sponsors, and I do believe this will genuinely help individuals who are vulnerable, and I just can't thank you enough on behalf of those individuals. Thanks.
Thank you. Members, any other discussion? Okay, seeing none, I would accept a motion to amend and do pass. That came from, okay, I have a first by Assemblymember Kasama, a second by Assemblymember Told. Any discussion on the motion? Seeing none, all those in favor, please signify by saying aye. Aye.
Aye.
Ms. Duran?
Aye.
Okay, perfect. Any opposed? Okay, motion carries. I will assign that floor statement to Assemblymember Tolles. Okay, next item for work session, we're going to jump into Senate Bill 290. Ms. Pasloff-Thomas?
Thank you, Madam Chair. Senate Bill 290 enacts provisions relating to prescription drugs for the treatment of cancer. It is sponsored by Senator Lang and heard on April 30th. There are two proposed amendments by the sponsor. The first is to revise the provisions of the bill requiring an insurer to disclose the name and qualifications of each person who will review the application for an exemption, to remove the requirement that the name of each such person be disclosed, but retain the requirement that the qualifications of each such person be disclosed, and amend the effective date of the bill from October 1, 2021 to January 1st, 2022.
Thank you, Ms. Pasloff-Thomas. Members, any discussion on the bill or amendment before you? Okay, members, seeing no questions, I would accept a motion to amend and do pass. I have a first by Vice Chair Carlton. I have a second by Assemblymember Considine. Any discussion on the motion? Vice Chair Carlton?
And thank you very much, Madam Chair. And there was a lot of conversation about this bill when we had the hearing. Medicaid was in, Medicaid was out. Knowing that PEB has put a fiscal note on this bill is destined for Ways and Means, and we will continue to have the conversation about Medicaid. I am getting some numbers right now, and they're looking fairly promising, but don't want to guarantee anything to anyone. But so there is another stage that this one will go through, and we'll keep having those conversations. I don't want people to be apprehensive because they think we're providing care to one group and not another. That is going to be a continuing conversation. I know there's some people in this building that don't believe me when I tell there's going to be a continuing conversation, but there really will be. I don't put stuff on the record that I don't stand behind. So thank you very much.
Okay, members, any other discussion on the motion? Okay, all those in favor, please signify by saying aye. Aye. Opposed?
Aye.
And then Ms. Duran?
Aye.
Perfect, thank you. Motion carries. Since that is going two ways, there's no need to assign a floor statement. Okay, next item, we are going to jump back to Senate Bill 209. Ms. Paslow-Thomas?
Thank you, Madam Chair. Senate Bill 209 revises provisions relating to employment. It is sponsored by Senator Donate and heard on April 28th. There are two proposed amendments, and there is a mock-up attached behind this. The first is to delete subsection 11 of section 1 of the bill, which exempts certain employers and employees from the provisions of section 1. And the second is to amend the bill to add additional co-sponsors to the bill.
Thank you, members. Any discussion on the amendment before you? Okay, seeing none, I would accept a motion to amend and do pass. I have a first by Vice Chair Carlton, a second by Assemblymember Marzola. Any discussion on the motion? Okay, seeing none, all those in favor, please signify by saying aye. Aye. Opposed? Would the nays please raise their hand? I have Assemblymember O'Neill, Assemblymember Kasama, Assemblymember Dickman, and then Ms. Duran?
Yes.
Okay, motion carries. I will assign that floor statement to Assemblymember Considine. Okay, now we are going to go back and take the rest of the items in order. Ms. Paslow-Thomas, if you would present Senate Bill 103.
Senate Bill 103 prohibits certain insurers from discriminating based on the breed of a dog at a property. It is sponsored by Senator Scheibel, and it was heard on April 21st. There is one proposed amendment, and that is to change the effective date of the bill from passage and approval to January 1, 2022.
Members, any discussion? Okay, seeing none, I would accept a motion to amend and do pass. Oh. Okay. I have a first by Vice Chair Carlton, a second by Assemblymember Dickman. Any discussion on the motion? Okay, all those in favor, please signify by saying aye. Aye. Opposed? Will the nays please raise their hand? I have Assemblymember O'Neill and Assemblymember Kasama in the nay. Assemblymember Duran?
Yes.
Okay, perfect. Motion carries. I will assign that floor statement to Assemblymember Dickman. Okay, next, Senate Bill 112.
Senate Bill 112 exempts certain products for the treatment of domestic animals from regulation under state law. It is sponsored by Senator Hansen and heard on April 26th, and there are no proposed amendments.
Members, any discussion on the bill before you? Seeing none, I would accept a do pass, a motion to do pass. So moved. Have a first by Vice Chair Carlton. Second. Have a second by Assemblymember O'Neill. Any discussion on the motion? Okay, all those in favor, please signify by saying aye. 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 Opposed? Assemblymember Duran?
Aye.
Perfect. Motion carries. I will assign that floor statement to Assemblymember O'Neill. Next up is Senate Bill 145.
Senate Bill 145 requires provisions relating to financial institutions. It is sponsored by Senator Spearman and heard on April 23rd. There are no proposed amendments.
Okay, any discussion on the bill before you? Okay, seeing none, I would accept a motion to do pass. So moved. I have a first by Vice Chair Carlton. Second by Assemblymember Tolles. Any discussion on the motion? Okay, seeing none, all those in favor, please signify by saying aye. Aye. Opposed? Will the nays please raise their hand? I have Assemblymember Dickman in the nay and Assemblymember O'Neill as a nay. Assemblymember Duran?
Aye.
Aye. Okay, I have Assemblymember Duran as an aye. Motion carries. I will assign that floor statement to Assemblymember Martinez. Okay. Next on our agenda is Senate Bill 229.
Senate Bill 229 revises provisions relating to the practice of pharmacy. It is sponsored by Senator Ratty, and there is one proposed amendment, and that is by the sponsor, and there's a mock-up attached. It is to amend Section 2 of the bill to, 1, retain provisions requiring a practitioner in order to enter into a collaborative practice agreement to agree to obtain the informed written consent from a patient who is referred by the practitioner to a pharmacist pursuant to a collaborative practice agreement. 2, provide that such provisions do not require a patient to obtain a referral from a practitioner before a pharmacist may engage in the collaborative practice of pharmacy or collaborative drug therapy management. And 3, retain provisions requiring a pharmacist to obtain the informed written consent of a patient before engaging in the collaborative practice of pharmacy on behalf of the patient. Also amend Section 3 of the bill to make conforming changes to account for the amendments to Section 2.
Thank you so much, Ms. Pasaloff-Thomas. Members, any discussion on the bill or the amendment before you? Yes, Vice Chair.
And thank you very much, Madam Chair, and I appreciate the sponsor hearing my concerns and addressing them. I think it's very important that the patient have information. It may not be something that's that deep, but at least they need to understand what the relationship is as they move through the healthcare system. And we've done a lot in this building for transparency's sake, and I believe keeping this provision in, and I just want to thank the senator for hearing our concerns and addressing them in the amendment.
Thank you so much, Vice Chair. Members? Okay, seeing none, I would accept a motion to amend and do pass. Have a first by Vice Chair Carlton. Have a second by Assemblymember Marzola. Members, any discussion on the motion? Seeing none, all those in favor, please signify by saying aye. Aye. Opposed? Ms. Duran?
Aye.
Okay, motion carries. I will assign that floor statement to Assemblymember Marzola. Okay, next on our list is Senate Bill 293.
Senate Bill 293 revises provisions relating to employment. It is sponsored by Senator Cannizzaro and heard on April 28th. There is one proposed amendment by the sponsor, and that is to amend the bill to add Assemblywoman Duran as a joint sponsor. Just as a side note, there was discussion to add Senator Neal also as a joint sponsor. Legal looked into this, and it's already been done in the Senate, but it was a timing issue in terms of printing the additional sponsors on the face of the bill, so they are already included on the first reprint of the bill.
Thank you, Ms. Pasloff-Thomas. Thank you, Ms. Pasloff-Thomas. And then just to clarify, Senator Neal was already amended on the Senate side, just omitted from the first reprint. And then the amendment is to add Assemblymember Duran. Okay, members, any discussion on the amendment or the bill before you? Assemblymember Tolles.
Yes, thank you, Chair, and I just appreciate talking to stakeholders, confirming that this really puts us in line with case law Uveno versus Rizzo, and aligns us with federal law. As a personal note, I remember speaking at a professional women's panel about 10 years ago when a report had just come out called Mind the Gap, and talking about how this impacts the long-term trajectory of wage earnings for women. And so I'm very supportive of this bill and thank the sponsor for bringing it forward.
Members, any other questions? Okay, seeing none, I would accept a motion to amend and do pass. Have a first by Vice Chair Carlton. Second by Assemblymember Tolles. Any discussion on the motion?
Thank you very much, Madam Chair, and I totally understand where folks are coming from with this. I have been extremely lucky in my life that I've always had a collective bargaining agreement, so I didn't have to worry about this level of discrimination. Thank you very much.
Thank you, Vice Chair. Okay, seeing no further discussion, All those in favor, please signify by saying aye. Aye. Opposed? Ms. Duran?
Aye.
Okay, motion carries. I will assign that floor statement to Assemblymember Duran.
Thank you.
Next on our agenda is Senate Bill 327.
Senate Bill 327 revises provisions relating to discriminatory practices. It is sponsored by Senator Neal and Harris, and it was heard on April 28th. There is one proposed amendment by the sponsor, and that is to amend Section 8 of the bill to provide that the provisions of the section do not apply to a city if, one, the city has a civil service commission that appoints a chief examiner, and two, the chief examiner serves at the pleasure of the commission, is not answerable to any officer or body of the city other than the commission, and is not a human resources director. Thank you.
Thank you, Ms. Pazloff-Thomas. Members, any questions on the bill or amendment before you? Okay, seeing none, I would accept a motion to amend and do pass. So moved. Do I have a second? Or Assemblymember Marzola, seconds. Any discussion on the motion? Assemblymember O'Neill?
Whoops, sorry about that, Chair. Thank you, Chair, for the time. I really appreciate Senator Neal working on this. The first part of the bill dealing with the discriminating practices all related to hair was, I will say, was very enlightening to me, and I would like to support. However, it's the second part, even with the amendment that Senator Neal proposed on the testing, that I need to hear more from the rurals. I think it really impacts them when they can't afford it currently. So I will be a no on this until I hear more from the rural counties and governments on their impact.
Assemblymember Kasama.
Thank you, Chair. Yes, I'm completely in favor of no discrimination on the hairstyle, but the testing, and particularly in Section 7(3), where it's still it's a Category E felony, and we're trying to decriminalize things. And so I just thought that was too extreme, and unfortunately have to vote no because of that. Thank you.
Thank you. Members, any other discussion on the motion? Okay, all those in favor, please signify by saying aye. Aye. Opposed? Nay. Will the nays please raise their hand? I have Assemblymember O'Neill, Assemblymember Kasama, Assemblymember Dickman. Ms. Duran?
Aye.
That's an aye for Ms. Duran. Motion carries, and I will take that floor statement. Okay, last on our work session agenda is Senate Bill 408.
Senate Bill 408 revises provisions relating to the State Board of Pharmacy. It was sponsored by the Senate Committee on Finance on behalf of the Office of Finance of the Governor. It was heard on April 26th, and there are no proposed amendments.
Members, any questions on Senate Bill 408? Vice Chair?
Madam Chair, my notes are not complete. Was there an amendment proposed to this, or did I make the wrong notation on the wrong bill? If I could ask for clarification. Apparently not. There are no proposed amendments to the bill?
Yes, and there are no amendments to the bill, Vice Chair Carlton.
Thank you. I had written down an amendment, but it might have translated over from one bill to the other. So thank you very much, Madam Chair, if you're ready for a motion.
Okay, I am ready for a motion, Vice Chair.
Do pass.
Thank you. A second? I'll second. Second by Assemblymember Marzola. Any discussion on the motion? Okay, seeing none, all those in favor, please signify by saying aye.
Aye.
Opposed? Will the nays please raise their hand? I have Assemblymember Kasama and Assemblymember Dickman as a nay. Assemblymember Duran?
Aye.
Okay, motion carries. I will assign that floor statement to Assemblymember Hardy. Okay, members, that brings us to the end of our work session. Thank you, and thank you, Ms. Pasloff-Thomas, for walking us through those. Okay, now that we're going to move into the bill hearing portion of our agenda. We have 2 bills for today. I do want to let members know I will be taking those out of order. We have some guests with us today for Senate Bill 179, so I would like to start with Senate Bill 179. Looks like I have everyone on. I'm just going to grab my participant list really quick to make sure I call the right people up. Okay, so members, I will now open the hearing on Assembly Bill 179, which revises provisions relating to sign language interpreting and real-time captioning. I believe we have Miss Adrienne Navarro on Zoom with us to present.
Yes, hello. Good afternoon, Chairwoman Howdigy and members of the committee. We would like to thank you for the opportunity to introduce Senate Bill 179 on behalf of the Interim Committee on Seniors, Veterans, and Adults with Special Needs. For the record, my name is Adrienne Navarro, Social Services Chief for the Nevada Aging and Disability Services Division, and I will be co-presenting with Jennifer Montoya, Social Services Program Specialist. As Ms. Montoya is an individual who is deaf, we do have a sign language interpreter with us today. I would like to take a moment to ensure that both Ms. Montoya and the interpreter are pinned, and those who rely on sign language have access prior to starting the presentation. So Ms. Montoya, are we set and ready to go? Perfect.
Yes, I can see.
Perfect, thank you. So to open, the intent of this bill is to increase the quality of sign language interpreting services statewide, provide a pathway for interpreters to achieve required credentialing standards, remove classification-specific language to align with other NRS language, and establish specific classifications and requirements by regulation. And lastly, provide standard qualifications for mentors. Established in 2001, Nevada Revised Statute 656A requires sign language interpreters to hold certain professional credentials to practice in the state. The original bill provided credential requirements that were in alignment with national standards for both K through 12 educational interpreters and also community interpreters. In 2007, revisions to NRS 656A lowered the credentialing requirements for K through 12 educational and community interpreters due to the lack of qualified interpreters to meet the demand. We now have structures in place in the state to support interpreters and interpreter development. I will now turn over the presentation to Jennifer Montoya, who will go through the sections of the bill and explain the changes throughout the bill. As I mentioned earlier, Ms. Montoya is an individual who is deaf, so I would like to emphasize the importance for anyone speaking to please state your name prior to speaking. Also, when Ms. Montoya is speaking, please engage by viewing her, not the interpreter. Although her voicing will be through an interpreter, Ms. Montoya is the one speaking to the committee. Thank you.
Thank you, Ms. Navarro. Ms. Montoya, welcome, and when you are ready.
Thank you, Ms. Navarro. Again, for the record, my name is Jennifer Montoya. I am the Social Service Program Specialist for the Nevada Aging and Disability Services Department, ADSD. Before I go ahead and give you some in-depth information about this bill, I wanted to take the time to explain to you the interpreting process and how having a qualified interpreter impacts those who are using the sign language interpreter. Interpreting involves several different processes. First, interaction, linguistics, the environment that they're in, and the goal of what the interpreter is there to do. and that is to facilitate communication so that there is equal access to information and understanding. A qualified interpretation will vary depending on the interpreter's knowledge, skills, and experience. The minimum certification requirement impacts deaf children and the education that they have access to, as well as adults having access to communication. NRS 656A has not been changed for 14 years, has had no refinement, and we feel like it's very important to have a state credential that aligns with a national requirement. Aligning certification requirements for sign language interpreters not only increases the quality for access to education for deaf and hard of hearing children and adults, it also allows the state of Nevada to be able to bring in more qualified interpreters from all over the United States. This bill has a 3-year grace period that allows the current registered interpreters time to meet the requirements that would be instituted by passing this. Here in the state of Nevada, we have deaf and hard of hearing children who are not receiving the appropriate education that they deserve, and that's because they are mainstreamed with sign language interpreters who are underqualified or not qualified at all. The interpreters do not have the interpreting skills needed in order to work in an educational setting to provide the support so that they can develop as they need to. It is really unfortunate that the students are learning sign language and communicating through a sign language interpreter. And the reason for that is because they don't have any role models or peers that are deaf and hard of hearing that they can learn from, or family members at home that use sign language as their mode of communication. So this can be very dangerous because it affects their ability in order to have relationships to be able to become independent later in life. In order to help our deaf and hard of hearing children receive the educational opportunities they deserve, we want to give the state credential requirement a higher level so that the deaf and hard of hearing students can have appropriate accommodations to succeed. I will go ahead and take a moment now to explain this bill and the different parts that we want changed. Starting with Section 1, we want to have new language to explain that the post-secondary educational setting should have changes that include new definitions, and we want to add that to Section 1. Section 7, we want to waive sign language interpreters or part providers that are nonprofit. We want to remove that. Section 9 includes the largest change for this bill. For Section 9, we would like to increase the minimum certification requirement for K-12 educational interpreters and community interpreters to align with the national standard as it was in 2001. Section 9 gives a temporary registration for interpreters to have a limited amount of time to improve their skills and their knowledge in order to meet that national standard. We want to remove the language in Section 9 following the changes to remove the classification so that the language is in line with the removal of that. Section 10 allows the division to establish qualified professional mentoring and additional professional classifications for sign language interpreters. Section 18 gives the grandfathering allowance a limited time for currently registered interpreters. And this would only impact 20 interpreters who are currently registered if these changes were to be made. The last section is 3, 4, 6. The last section again, 3, 4, 6, 10, 11, 12, 14, 15, 16, 17, and 20. We propose the language be refined to align with the standard language and registration requirements. We do want you to know that the amendments to this bill on the Senate side, in order to clarify the definitions of sign language interpreters, specifically in a K-12 setting, educational interpreters. All communication with students in an educational setting or other activities provided by the public school system, whether it be the school district, private schools within the state of Nevada. This amendment has already been removed and it has had a fiscal impact on the school district. Thank you, and we appreciate your time for listening. Does anyone have any questions or comments they would like to make?
Thank you so much, Ms. Montoya. I am going to go to the members now to see if they have any questions. Assemblymember Kasama.
Thank you, Ms. Montoya. My question is just for me to just learn better how this is handled in our schools. So in the primary or universities, is it a request that a student in a class needs it? And then obviously this bill is to make sure that they have the proper credentials, but then the request is made by a teacher or parent to have the interpreter come into the classroom. I'm just curious, is that the process now? And then my second question is, have we ever had a time where we haven't had enough interpreters if, there's a great need, particularly in one school versus another? How might that work, just for better understanding of the current process? Thank you.
So to your first question about the process of how you request a sign language interpreter, it is within the student's IEP, their individualized education plan. The accommodations are outlined there. So that's where the interpreter request would be. It would be in their IEP, and the school district would follow through. Deaf adults who are attending a post-secondary institution would request their interpreters when they had classes, school events, meetings with their teachers, so on and so forth. Hopefully that answers your first question. The second question you had in regards to there being a need, would you mind repeating the second portion of your question in regards to there being a need?
I'm just wondering if at times do we run out of enough interpreters? So I don't know how many is hired or available at any one time. Have we ever had an issue where we've run out of interpreters, or do we always make sure that we have enough for everybody?
Yes, the answer to that is yes. Unfortunately, we have a need, and we have a need even at a national level. It's something that every state faces, that there is a need. But in the state of Nevada, we have gaps because of the fact that we don't have enough of qualified interpreters. We have people who know sign language, but they're not trained in the process of providing sign language interpretation. And so they use people who can just sign to interpret, but they're not qualified. They don't have the knowledge of the process of how it works. And so they're using that to quote unquote cover the gap. So we have a lot of gaps here in the state of Nevada, and that's what we're trying to fix, is by making sure that we're providing qualified sign language interpreters specifically for students in a K-12 setting, so they have access to that education.
Follow up?
Thank you so much for the explanation. So if we have a shortage, obviously the goal is to make sure that they're all qualified. But if we have a shortage, would you still allow some people that don't meet the higher levels of credentialing so that we could attempt, maybe not in a most ideal way, but still attempt to meet the needs?
And this is Jen again, Ms. Montoya again, these proposed changes where we have temporary grace periods, in this case for 3 years, in order to give them the time to improve their skills, to get that knowledge, to take the exams they need in order to get the results to make them qualified interpreters. So we do have those temporary provisions in order to cover the gaps if there are needs that cannot be met.
Thank you. Members, any other questions? Assemblymember Dickman.
So, thank you, Chair. My question has to do with the fiscal notes. And I see a lot of them went away with the first reprint, but Clark County seems to still have quite a large one. Will that go away?
Good afternoon. This is Ricky Robb, Deputy Administrator for Aging and Disability Services. When we were presented with the amendment, all counties stated that they would be removing their fiscal notes. Unfortunately, we have not had been able to have direct communication with Clark County, but our understanding is yes, they are to be removed as the amendment is accepted.
Okay, sounds good. I don't understand why they were such huge fiscal notes to begin with, but thank you so much, and thank you, Chair.
Members, any other questions? Okay, seeing none, we will move into testimony in support. Thank you so much for your presentation, Ms. Montoya and Ms. Navarro. Is there anyone here in Carson City wishing to testify in support of Senate Bill 179? Okay, seeing none, is there anyone on Zoom wishing to testify in support? Okay, seeing none, we will move to the telephone lines. Broadcasting, could we check the phone lines?
Yes, Chair. To testify in support of Senate Bill 179, please press star 9 now to take your place in the queue. Chair, there are no callers in support at this time.
Thank you so much, Broadcasting. Is there anyone in Carson City wishing to testify in opposition? Is there anyone on Zoom? If you would just turn on your cameras. Okay, seeing none. Broadcasting, could we check the phone line for opposition?
To testify in opposition of Senate Bill 179, please press star 9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you. Broadcasting, is there anyone in Carson City wishing to testify in neutral? Seeing none, is there anyone on Zoom wishing to testify in neutral? If you would just turn on your camera so I could see you. Okay, Broadcasting, could we check the phone line for anyone in neutral?
To testify in neutral on Senate Bill 179, please press star 9 now to take your place in the queue. Chair, there are no callers for the neutral position at this time.
Thank you, Broadcasting. Ms. Montoya or Ms. Navarro, would you like to give any closing remarks?
Yes. That up here. So this is Adrienne Navarro for the record. In closing, I wanted to mention that this bill was amended. Oh, sorry, that's Jen's part. Again, Adrienne Navarro for the record. We appreciate the committee's time and interest in hearing this bill, as well as all questions from the committee members. This bill highlights the importance of quality interpreting for individuals who are deaf and hard of hearing as it relates to their access to communication in all areas of their life. Children who utilize American Sign Language as their primary language need qualified, quality interpreters throughout their education in order to access the same information in the classroom that hearing children do. A sign language interpreter who is qualified to provide these services results in an individual who has access to quality and effective communication. Thank you so much for your time today.
Thank you so much, Ms. Navarro. Ms. Montoya, would you like to give closing remarks?
No, this is Ms. Montoya. I do not have any closing remarks at this time.
Well, thank you so much for being here and for presenting Assembly Bill 179. We will now close the hearing on Assembly Bill 179. Okay, that brings us to our last item, our last bill on the agenda for our hearing today, which is Senate Bill 79. I believe we have our presenters on Zoom with us.
3-5.
Good afternoon. Oh, perfect. Okay, just wanted to make sure you were there. Okay, I will now open the hearing on Senate Bill 75, which revises provisions relating to unemployment compensation. Welcome to the committee when you're ready.
Thank you, Chair Howdigy and members of the committee. My name is Elisa Caffaretta. I am the director of DEETR. I am joined by our leadership team, Chris Sewell, Jeff Frischman, Jenny Castleman, Troy Jordan, Dave Schmidt, and Linda Parvin on the Zoom. We are presenting SB 75 as amended on the Senate side. Before we started, I just wanted to briefly sort of give you a short rundown of what SB 75 is not. I just want to make sure that the committee is aware this is not the only legislation addressing the issues that DEETR has been working through in the last year. To give you an update, I wanted to be sure you are aware we have implemented most of the recommendations from the Special Masters Report and the Strike Force Report. Our budget closed last week, which has several improvements and allocations that will address specific issues that the agency has been dealing with. We are working with the governor's office to fund modernization of our program as outlined in the Every Nevadan Recovery Plan. And there are several other bills making their way through the process that make adjustments and changes to DEETR's operations that you may be seeing before you in the next few weeks. So we have several programs and budget items that are offering support and assistance to the agency as well as employers and claimants. So SB 75 is a bill that makes changes in state law that will streamline our operations when we are faced with future economic disruptions. Several of these changes are needed to bring our statute into conformance with federal law or regulations or updated court cases or guidelines. There are two proposed amendments today that we'll go over at the end that are for your consideration. So I'm just going to give a very high-level overview. I know there's been a lot of discussion of our programs this session. So I'll give you the high-level overview, and then we're happy to answer any questions. So again, this bill provides changes that are needed for us to more effectively do our work. One of the first provisions is that DEETR was approved for an additional attorney position. This bill would make that an unclassified position, which is consistent with all of the attorney positions in the state. There's a provision in the bill that brings our confidentiality requirements into alignment with federal law and streamlines our data sharing operations. This won't change any of the existing data sharing agreements that we have in place, but it will make it easier for us to set these up with various local, state agency, and federal governments. There is a provision that corrects a math error that was created in SB3 during the special session. There is a provision that allows DETR to provide electronic notices for any decisions or updates on a claim in addition to mailing a notice to a claimant or an employer. There's a provision that allows DETR to offer state extended benefits whenever those are approved by the Department of Labor. There are provisions clarifying the definitions of educational professionals and so that it is more clear the folks who are not eligible for unemployment benefits under federal guidelines. There is a provision that requires all legal filings to be made at the state administrative office in Carson City to ensure we can respond to any legal actions in a timely manner. There's a provision that would allow employers to request refunds of contributions, overpayments for a period greater than 3 years to respond to a review that we had. There's a provision that prohibits charging fees to both the state or the claimant in any appeal hearing that happens. And there are provisions codifying the charging relief that we gave to employers in the emergency regulations so they won't be charged additional amounts in any future quarters or years because we're codifying that relief. And then, as I noted, there's an amendment from DETR, and basically what that does is follow the language that was approved by the Department of Labor when it came to the provisions regarding state extended benefits and charging relief. So that just brings it into compliance with what the Department of Labor said it would approve. And there is also a friendly amendment from the Public Defender's Office regarding using DETR lists for jury selection. So that is the super high level. We're happy to answer any questions and provide additional information if you would like that.
Thank you, Director Caffaretta. I am going to go to members for questions. I'm going to start with Vice Chair Carlton.
Thank you very much, Madam Chair. So I'll start with one of the last comments that was made about the friendly amendment for jury selection. I had thought a couple of years ago or a couple sessions ago that we had already addressed that. And I believe there's been an issue of DETR not sharing the list. So if you could expand upon that, because I thought we had already said that that list should be part of the jury pool.
I'll take that. For the record, Troy Jordan, Senior Legal Counsel of the Employment Security Division. In the fall of 2019, we were attempting to promulgate regulations to make that jury selection process, our jury list provision, conform with the federal regulation 20 CFR 603. At that point, the Department of Labor said the way that we were doing it was not in conformity with that law. They told us we needed to cease the program until we came into conformity with that law. We have been working on a solution since that time. The public defenders who are here, who have proposed this amendment, gave us a lot of help in drafting that solution. This solution in the proposed amendment by the public defenders has been approved by DOL as in conformity. If the vice chair would like, I can get into the intimate details of that, but basically what it amounted to was the Department of Labor has ruled that a jury commissioner does not meet the definition of a public official of as laid out in 20 CFR 603.2. Specifically, that definition requires that a person who is to receive the data is either an elected official themselves, an agency member or person in the executive branch, or a member of an educational institution that comes with several definitions. In this state, we have several jury commissioners who are actually employees of the judiciary and not of the executive branch, such as under the county clerk, and that is what created the problem. The solution that we have proposed with the amendment to SB 75 allows an administrative subpoena to be issued by a judicial person with subpoena authority, which is also an exception to the confidentiality provision, and is able to subpoena that jury list, at which time it will be provided directly to that subpoenaing authority, which in this state would include at least the chief judges of the individual judicial districts. The Department of Labor has recently signed off on that and actually made edits to the language in the amendment sent over by the public defenders.
And thank you very much, Madam Chair. So I just wanted to make sure that we had the record clear. I had thought we had fixed this, but apparently there was a glitch someplace, so we have to jump through a few more hoops to make the feds happy. So that explains that one.
And Madam Vice Chair, before you go on, if I could just have the gentleman who answered Vice Chair's question clearly state your name for the record. Our secretaries just had a difficult time getting that.
It's Troy, Troy, Jordan, Jordan.
Thank you, Mr. Jordan. And sorry, Vice Chair, please continue.
No, and thank you. So my next questions go to, I guess it's page 12 of the bill, section 6. Earlier this session, seems like a very long time ago, but we know we've only been here for about 102 days, but nobody's counting. So the Legislative Commission had passed a regulation that dealt with the issue of school district support staff not being able to get unemployment. They were put literally in a catch-22. They were not working, they were not told they were laid off, but they were never given a guarantee of a job coming back. So when I read section 6, I'm wondering, how does this affect support employees in the school district being able to access unemployment benefits?
Thank you for the question, Elisa Caffaretta, for the record. Yes, if you, certainly this is a little bit confusing if you are just reading one section of the bill and don't have the whole story. As you know, the Legislative Commission did approve the regulation that we put in place for this summer only to provide unemployment benefits to education support personnel. So specifically not teachers and administrators, but all the other folks who support our schools and classrooms, the folks who work in lunchrooms, the folks who drive the buses, the folks who clean up the schools in between sessions and days. So that is the regulation specifically applies to those support personnel, takes them out of that limbo, as you say, and provides unemployment benefits to them. This language in section 6 and 7 applies more to our regular operations. So the federal law says that you cannot provide unemployment benefits to education professionals, so teachers, substitutes, administrators, professors between terms. And this language was needed to very clearly spell out those folks who are exempted and cannot receive unemployment benefits when they have a reasonable assurance that they are coming back to their jobs after the breaks.
If I may, Madam Chair, if you could point out the education professionals part, because I'm just seeing if a person performs services in more than one capacity for any educational institution. So am I missing, where am I missing the professionals section if this works in conjunction with another section?
Jeff Frischman for the record. What we were having a difficult time in
the prior language in the interpretation of school wages and what school wages could be used and not. This regulation is simply clarifying that language to ensure that we don't have different interpretations within our own program. Basically, the appeals referees were interpreting it different than the adjudicators. There was a different set of interpretation, and this cleans up the language that it will be interpreted and how those wages can be applied moving forward so that it brings consistency and ensures consistency in how we're issuing determinations and decisions.
And thank you, Mr. Frischman, but my question was, where does it say that this is professionals and not for everyone?
This is Elisa Caffaretta again. So if you look at section 6, subsection 1, basically it starts out with, except as otherwise in this section, benefits are based on service in an instructional, research, or principal administrative capacity in an educational institution. So that is clearly sort of the statute language for teachers and principals. And in section 7, it's the same language, instructional, research, or principal administrative capacity. So that is clearly focused on the professional educators, and then the regulations specifically define education support personnel. So you'd have to kind of look at the two things together to make the distinction.
And thank you for pointing it out. So it's basically the language in line 6 and 7 on page 12 under section 6 that makes sure that this does not apply to support employees.
Elisa Caffaretta, yes.
Okay, thank you. That was the question. Thank you very much.
Assemblymember Tolles? Oh, okay, perfect. And I have, members, any other questions? Assemblymember Kasama?
Thank you, Chair. My question has to do with the amendment section under section 3, subsection 10. It's the First Amendment section on the top here. This is just for perhaps an educational thing, but it has to do with the jury trial or the trial jurors again. Can you just inform me why it has furnished the name, address, and date of birth of persons who receive benefits in any country? Is that like you get a pension from another country outside of the U.S.? I'm just curious what that really means and I guess why it's there. Thank you.
This is Elisa Caffaretta for Dieter. I believe that the public defenders are here to present their amendment to you because it's a friendly amendment and they can present it, but I do believe that is actually a typo and it should say county, not country. Listen.
That's my understanding, but I'll defer to the public defenders.
So Chair Elisa Caffaretta, again, Chair Hadegay, I don't know how you want to present the amendment. Let us know how you want to do that.
Would you like to present it, or would you like the person who proposed the amendment to present it? We can actually hear it now. I think that would be best.
Yes.
Would you like to present it, Director, or would you like the sponsors of the amendment to present it?
This is Elisa Caffaretta. We would like to give the sponsors the opportunity to present their amendment.
Okay. Welcome. I see you making your way down. Thank you. And members, you should all have a copy of the amendment proposed to Senate Bill 75. It was proposed by the Clark County and Washoe County Public Defender's Office.
Good afternoon. Kendra Birchie with the Washoe County Public Defender's Office. For the record, I am just trying to pull up the law right now because we were not trying to change anything that was.
Ms. Birchie, do you just want to walk the committee first through the amendment?
Absolutely. Thank
Okay,
you
perfect.
so
Thank you.
much. And I appreciate, just to confirm, it is on Nellis because it's not on Nellis on my end.
1 second, and I will check for Ms.
Thank you.
Birchie. Okay, it looks like maybe it was just not released to the public, but I do see that the amendment is posted to Nellis, so we will have our committee manager release that to the public. But members, you have to be signed into your Nellis in order to see the amendments, remember. Okay, thank you. Ms. Birchie, if you want to proceed.
Thank you, and I appreciate that. And also, just to confirm, we did provide a letter in support, which does outline some of the research that we undertook in order to get to the conclusion in the amendment where they're at, which provides additional information. We did provide that, so I also don't see that uploaded, so please let me know if you did not receive that. Need to start by saying, just because there is pending litigation regarding this issue, that we believe that what's currently in statute is appropriate and is correct and does not need to be modified. However, we understand that Dieter has additional obligations besides just the Public Defender's Office. And so in order to ensure that we do have access to this information, that's why we proposed this amendment. So for amendment number 1, we're simply modifying who can access and who can request the information from Dieter. And so it's changed from, instead of the district court judge or the jury commissioner, to in response to requests from a court official with subpoena authority. So that's what the changes that's necessary, from my understanding, from the Department of Labor in order to ensure that we can have access to that. So it's someone who has that authority, the subpoena authority. The additional portions of the bill is just ensuring that the current law is in place. So we are not attempting to change anything else from current law. For amendment number 2, it's just deleting that section 19. Section 19 had just indicated that the amendment, or what was in the bill, was just saying that Dieter wouldn't have to provide this information and that couldn't be used. So we're deleting that section again to ensure that it is being provided. So in the question, I believe it should be county, just in reviewing the statutes. I will double check that and provide an amended proposed amendment if that is the case.
Members, do you have any questions for Ms. Birchie? Thank you, Ms. Birchie. And Assemblywoman Kasama, did you have any follow-up for Dieter or Director Caffaretta?
No, I'll just look forward to the clarification.
Thank you. Assemblymember Dickman. Oh. Yeah.
Thank you, Chair, and thank you for being here, Director. I just wanted to clarify that whether or not this would apply to unemployment for teachers who are on their summer break or whatever break, who will be coming back, they would still not be eligible for unemployment under this, correct?
Elisa Caffaretta, for the record, that is correct. Federal law specifically does not allow for unemployment for teachers who are on a summer break and expect to come back. And nothing in this bill would change that.
Okay, I didn't think so, but I just wanted that clarification. Thank you, and thanks, Chair.
Assemblymember Tolles?
Thank you, Chair. And just to follow up on that, and for non-educational staff, just to clarify, let's say you're a bus driver and you only work 9 months out of the year. Does that apply the same way for them? They wouldn't be receiving unemployment for summer when they wouldn't be employed otherwise?
Elisa Cafaretta, for the record. Typically, support personnel have been excluded from getting unemployment benefits. We did, because of the unique situation of the pandemic, just pass emergency regulations that would cover support personnel for the summer of 2021. So that is bus drivers, janitors, lunchroom folks who are whether they're coming back in the fall or not, they would be eligible to apply for unemployment. They still need to follow all the other rules. So if they're offered a bona fide job that they refuse, they would not be eligible, those sorts of things. But there is a regulatory exception for this summer only for support personnel.
Okay, thank you. I guess my other questions would be fiscally related, so we could maybe address that elsewhere. Thank you.
Okay, members, any other questions? Okay, I do have a couple of questions, Director Cafaretta. I want to start with the first one with section 2.5, and I know you touched on this, but I just, in the beginning regarding the attorneys, the positions for attorneys, but I know this is in statute saying for the purpose of ensuring the impartial selection of personnel, on the basis of merit, the administrator shall fill all positions in the division from the registers prepared by the Division of Human Resources. And then you guys have exceptions, like the exception of the administrator and senior attorney, but then you've also added in the exception for all positions for attorneys. So it removes them from that kind of protection for an impartial selection. So can you walk me through that?
Sure, Elisa Cafaretta for Dieter. So basically what this language is discussing is that most people in state employment go through the state hiring process, which provides these impartial selection protections, and they end up in what's called classified service. So they have protections throughout their service. This particular section in section 2.5 is really just identifying the positions that are what are called unclassified positions in state service. So the administrator and the senior attorney have always been unclassified positions. They serve at the pleasure of the director or the administrator in these cases. So we've never had additional attorney positions, but we did in this budget get approval for an additional attorney. All the attorney positions in the state, whatever agency they're in, are unclassified positions. So this just would make that consistent with keeping all the attorney positions unclassified. Does that answer your question?
Yes, it did. I know I wasn't writing down quickly enough, and I remember you now mentioning at the beginning of your presentation that these were new positions added in this session. Okay, I also have another question regarding, let me get there, section 4. I don't understand the purpose of the 75 to 66 and 2/3. So could you walk us through that? And it's the section where it says, oh, okay, perfect.
Yeah, Elisa Cafaretta with Dieter. I have cautioned my team many times on not trying to do math in front of a committee. So we're going to turn that over to our economist, Dave Schmidt, to explain to you.
Thank you. This is David Schmidt, Chief Economist for Dieter, for the record. In effect, SB 3 during the special session in the summer changed the provisions where someone who has some earnings during a week of benefits is allowed to receive those benefits. And it raised a limit. Previously, if you earned more than your weekly benefit amount, you were no longer eligible for benefits. SB3 raised that to if you earn less than 1.5 times your weekly benefit amount, then you could still be eligible for benefit payments. However, with the 75% provision, what effectively happens is someone's weekly benefit is reduced for any earnings that they have. And reducing benefits at 75% with math means that when you get to 1.33 times your weekly benefit amount, your weekly benefits have been reduced to 0. And so by reducing the 75% to 66 2/3%, that earnings reduction would reduce someone's benefits to 0 when they hit that 1.5 times weekly benefit cap, so that these two provisions can come back into alignment.
Okay, so Director Cafaretta, I also don't like math. So does this, that's true. Could you explain it to me again? Is this enhancing someone's benefit amount if they are bringing in additional benefits on their own or wages on their own, or is this decreasing their benefit amount if they are bringing in wages on their own?
David Schmidt again for the record. In practice, if someone has a, say, $400 benefit amount and they have $100 in earnings, so they are not in danger of this little cliff running out of benefits. Under existing law, if you have $100 in earnings, your weekly benefit amount would be reduced by $75. As changed in this bill here, your benefit amount would instead only be reduced by $66, rounded a little bit. And so you would end up with slightly more benefits for people who have earnings in order to stretch the point at which your benefits would be reduced to 0 out a little bit further to be in compliance with the changes that were made in SB3.
And this is Elisa Cafaretta. If I could follow up, the goal of the SB3 was to sort of give people more options in the beginning of the pandemic to allow them to sort of put together whatever job plus benefits they could and best support their families in an extreme situation. So this is just trying to make it consistent so that you get the full flexibility and you don't run into a math problem in trying to provide that flexibility to folks in an economic emergency.
Okay, perfect. Thanks. That was great explanation. I fully understand it now. Okay, now I do have just, looks like one other question, and it's just more expressing some uncomfort, as well, expressing my comfort level with a change, where throughout the bill, it's allowing DETR to either send their notices to someone who is receiving benefits by mail being served or now by electronic transmission. And I'm just a little uncomfortable with the fact that the only way DETR might get in contact with someone is by sending an email. Not everyone has access to email, and not everyone accesses our email every day. So it would make me more comfortable if it was by mail and email as opposed to mail or email, just because, again, if that is a denial, there is a limitation on how much time someone has to file an appeal. And if you send a denial via email and they don't check their email, letting DETR know that, I'm sorry, I just didn't check my email in time to file an appeal, I don't think would be sufficient to grant them that right to appeal. So I just wanted to express not so much a question, more of an area I'm not comfortable with in the bill. Okay, members, any other questions? Assemblymember Dickman, round 2.
Thanks, Chair. Actually, it's your fault because you brought up, when you talked about the section where the 75 versus 66 2/3, I was just curious as to how that affects their total number of benefit weeks. To get that small.
David Schmidt again for the record. Effectively, for someone who has earnings during a week, there is no cap on the number of weeks that someone can necessarily receive. So someone who has earnings and receives partial unemployment benefits can stretch out the number of weeks in which they receive payment. What matters the most is how many dollars they have remaining in their entitlement. And so this would not, by the number of weeks, reduce the number of people who might be eligible, except that because they might have slightly more benefits paid, there could be a very marginal change on the end. But overall, there's no big impact on weeks because the most important thing is dollars.
Okay, thanks. Thank you, Chair.
Thank you. And I'm going to come back to myself around two because I did not finish asking my questions, but I noticed that there was also an exemption for Dieter, and I'm not sure, and sorry to spring this on my legal right now, but I'm not sure if this is something our legal counsel can answer, but I know that Dieter is exempting themselves also from being charged any fees. And so I wasn't sure if that was something that other state agencies also exempted themselves from. And I'm going to go to my legal counsel I'm going to start with my legal counsel first just to see if he has an answer on that second part of my question. Do you know, Mr. Quast, if this is common for state agencies to exempt themselves from being charged fees?
Thank you, Madam Chair. Sam Quast, Committee Counsel. I'm not familiar with any other provision that in existing law that does that, but that's certainly something I can look into and get back to you on.
Thank you. And then Director Cafaretta, maybe if you could just address in section 18.5 why Dieter is has that exemption for themselves.
Troy Jordan, Senior Legal Counsel to ESD for the record. If you take a look at NRS 19.035, it actually exempts all state agencies from court fees. There have been a few, and I don't want to name names, but a few recently that have tried to charge us filing fees. So I wanted to amend this section to make it abundantly clear that at least in 612 cases, which are supposed to be free for both sides, that they couldn't charge us. But if you take a look at and have your legal counsel look at NRS 19.035, it clearly states that the state agencies and sections of the state, including counties and cities, are not supposed to be charged by district courts.
And Madam Chair, if I might follow up on one of your previous questions about your discomfort with email notices, just wanted to be clear on the record that the language in this bill makes it an opt-in additional option for claimants. So mail notices will still go out. This was very strongly suggested by both claimants and especially employers whose businesses were closed and were not receiving the mail notification, that they really wish they could have opted in for electronic notification. But we are in no way eliminating the mail notifications that are required under state law.
Okay, thank you, Mr. Jordan, for answering that question regarding the fees. That explains it to me. And then thank you, Director Cafaretta. But just like in Section 5, the way I read it, it says an assessment must be mailed, electronically transmitted, or personally served. So it sounds like it's an or, right? They can either be mailed or they can be electronically transmitted. It doesn't sound like it can be both. And I think it would make me more comfortable if notices were sent to claimants both by mail or email. For that same reason stated, like you said, somebody might not be checking their mail, but they would get the email and vice versa. Okay. Members, any other questions before we go to testimony? Okay, seeing none, I am going to move us into testimony in support of Senate Bill 75. Is there anyone here in Carson City wishing to testify in support? Perfect. Welcome back, Ms. Birchie.
Thank you very much. For the record, Kendra Birchie with the Washoe County Public Defender's Office. Today, I'm testifying on behalf of my office, and I believe that you will also be hearing from representatives from the Nevada Attorneys for Criminal Justice, as well as the Clark County Public Defender's Office. We all worked on this language to ensure that we could get it correct. As I indicated previously, we do believe that the current statute does work and is proper the way that it's written. However, we understand that there may be other people who have different interpretations. And so I do appreciate Dieter working with us to ensure that we were able to create language that does allow for us to continue to have access to this very important information. As Assemblywoman Carlton mentioned, this negotiations had come out of Assembly Bill 207 in the 2017 session. I won't rehash the entire argument, but this was a lengthy hearing where it mentioned just how extremely vital it is for our criminal justice system to ensure that we have a fair representation on our juries. You'll hear from the other speakers as well more information as to why it's important. I can just say, as a trial attorney, it is very scary to go into a trial and have a Black or Hispanic or minority defendant and see only white members of the jury panel. So it is our goal to hope to make sure that we do whatever we can to try to get a fair and impartial jury that represents our community members. So we urge your support for these provisions. I am not here to comment on any other portion of this bill. And if our amendments are not accepted and the version of the bill that passed from the Senate were to be adopted, then we would be moved into opposition just because of how vital and important this is. Thank you.
Thank you, Ms. Birchie. Is there anyone else in Carson City wishing to testify in support of Senate Bill 75? Okay, is there anyone on Zoom wishing to testify in support? Okay, I do see a hand up. If you would just unmute your mic and begin. Just clearly state and spell your name for the record.
Deborah Westbrook, Deborah, Westbrook, Westbrook. Good afternoon, Madam Chairwoman and members of the committee. My name is Deborah Westbrook, and I'm an appellate attorney in the Clark County Public Defender's Office testifying for NACJ. Our support of SB 75 is contingent on the acceptance of our proposed friendly amendment that was submitted to this committee. The amendment deals with sections 3 and 19 of SB 75, and I can confirm that the use of the word country in section 3 was a typo. It should say county. Without our amendment, sections 3 and 19 will have a detrimental effect on jury trials and undermine the constitutional rights of Nevada's citizens to a jury that reflects a fair cross-section of our diverse community. In 2017, Nevada's legislature recognized that the best way to ensure that juries were reasonably representative of the community was to increase the number of sources from which jurors were selected. So the legislature passed a law requiring Dieter to provide jury commissioners with a list of individuals receiving unemployment benefits. Unfortunately, the current version of SB 75, without our proposed amendment, would eliminate this important source of potential jurors, undermining our Constitution and making jury trials in Nevada less fair. We reached out to Dieter to find a way to fix SB 75. We knew that several states, including New York, Connecticut, and Rhode Island, had successfully utilized unemployment information to create their jury pools for years. And we spoke with representatives of the judiciary in New York and Connecticut who confirmed that it was legally permissible to do so. We gave Dieter our legal analysis, which they shared with the Department of Labor, and the Department of Labor confirmed that the information could be provided to the courts when requested by a court official with subpoena authority. And we believe this is true even under our existing law. So to be clear, we support SB 75 with our proposed friendly amendment. But if that amendment were not to be adopted, we would be in opposition because of sections 3 and 19. Thank you.
Thank you for your testimony. Is there anyone else on Zoom wishing to provide testimony in support?
Yes, my name is Sharon Dickinson.
Ms. Dickinson, when you're ready, please begin.
Okay. My name is Sharon Dickinson. It's spelled S-H-A-R-O-N. Dickinson is D-I-C-K-I-N-S-O-N. And I'm testifying on behalf of the Clark County Public Defender's Office. I'm a Chief Deputy Public Defender, having worked in criminal trial and appellate practice for over 30 years. On behalf of the Clark County Public Defender's Office, we believe NRS 6.045 and NRS 612.265 as initially enacted do not create legal problems and no changes needed to be made. However, due to Dieter's concerns, our office is testifying in support of the proposed friendly amendments as accepted by Dieter that changes sections 3 and 19. We have no opinion on the remaining sections. If the amendments are not adopted for some reason, then we oppose SB 75. I first became aware of Dieter's first draft of SB 75 after it already passed through the Senate. I've been working on several cases in our office involving the underrepresentation of minorities on juries. I subpoenaed Dieter's statistics for an upcoming evidentiary hearing, and at this time I was told by a Dieter representative that SB 75, as it's currently written, would eliminate Dieter's obligation to provide the court with lists for the jury pools. Well, I know firsthand that including these lists is important because for most of my career, minorities have been underrepresented. However, once the Dieter list names were incorporated in 2019, our trial attorneys began seeing a difference. I immediately contacted our office's legislative representative, John Piero. I reviewed the law in this area and found a way to avoid the problems Dieter mentioned. I worked with the NACJ Legislative Committee with Ms. Westbrook, and we put together some changes in the statute. We met with Dieter, we listened to their concerns, and they submitted the proposed amendments to sections 3 and 19 to the Department of Labor, and the Department of Labor and Dieter subsequently approved. So we are asking that you adopt the friendly changes that we have submitted. Thank you.
Thank you for your testimony. Is there anyone else on Zoom wishing to provide testimony in support of Senate Bill 75? Okay, seeing none, broadcast, can we please check the phone line?
To testify in support of Senate Bill 75, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 663, please solely state and spell your name for the record. You'll have 2 minutes and may begin.
Good afternoon, Chair and members of the committee. My name is John McCormick, John McCormick. I'm the Assistant Court Administrator at the Nevada Supreme Court Administrative Office of the Courts. I'm calling in a limited capacity here to indicate that we support SB 75 with the Public Defender's Amendment. Currently, we think that there's an exception in federal law and that this would be possible under the existing statute, as Ms. Birchie indicated. However, in order to ensure that the courts are able to access these lists for the important activity of jury selection, we support the amendment and will be submitting those administrative subpoenas as soon as this becomes effective. Thank you.
Thank you for your testimony. Broadcasting, next caller.
Chair, there are no more callers in support at this time.
Thank you. Is there anyone in Carson City wishing to testify in opposition? Welcome, Ms. Magnus.
Madam Chair and members of the committee, for the record, my name is Annette Magnus, and I'm the Executive Director of Battleborn Progress. And we are here today in opposition to SB 75. During this pandemic, I've had friends and family go through the unemployment process, and I'm still helping many navigate this broken system. Section 18.5, carving out that Dieter can never be charged any fees, is unfair, as it looks like they are trying to be above the lawsuits and accountability people have been working towards. We need to streamline Dieter and make critical changes, but there needs to be access to due process and the judicial branch when necessary. We need to ensure we are not making it harder for people who are depending on the system in order to survive. Thank you for your time.
Thank you, Ms. Magnus. Is there anyone on Zoom wishing to testify in opposition? Okay, broadcast, can we go to the phone lines?
Testify in opposition of Senate Bill 75, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 265, please slowly state and spell your name for the record. You'll have 2 minutes and may begin. Caller with the last 3 digits of 265, please press star 6 to unmute on your end.
Good afternoon, Chair and committee members. For the record, I'm J.P. Kemp. It's J.P.K.E.M.P. Here on behalf of the Nevada Justice Association. And we are in opposition of SB 75 as currently drafted. We are encouraged by the friendly amendment put forth by the public defenders, as that would alleviate our concerns about the jury pool aspects of the bill. But I also wanted to speak to Section 13.5, which provides for the agency to designate a specific office for the service of process on petitions for judicial review that are filed by claimants who are appealing denial of benefits. This needs to be amended as this is currently done. Service of process like this could be deemed to be jurisdictional and mandatory, and someone could have their petition for judicial review dismissed if they didn't serve the right office. This should be amended and corrected so that the court would have the ability to direct corrected service on the proper office if the wrong office were initially served. Many petitions for judicial review in a number of different administrative proceedings are filed by people pro se without attorneys, and they often make mistakes like not serving the exact correct office, and they end up getting their cases dismissed on jurisdictional grounds if they don't do that. So there should be an amendment to provide for the court to be able to order corrected service if it's not done correctly and not just dismiss the cases. And so for that reason, we are in opposition to SB 75 is currently drafted. Thank you.
Thank you, Mr. Kemp. Broadcasting, next caller, please.
Chair, there are no more callers in opposition at this time.
Okay, great. Seeing no one here in Carson City for neutral, is there anyone on Zoom wishing to testify in neutral? Okay, broadcasting, can we move to the phone line?
Testify in neutral on Senate Bill 75, please press star 9 now to take your place in the queue. Chair, there are no callers for the neutral position at this time.
Thank you so much. Any closing remarks from our bill sponsor?
Elisa Cafferetta for Dieter. Just really appreciate the committee's time and the support of the legislature throughout this process. We know there have been many challenges, and we really appreciate your support to address these issues for claimants and employers. Thank you.
Thank you so much, Director Cafferetta. Okay, at this time, I will close the bill hearing on Senate Bill 75. Our last item on the agenda is public comment. While we give those listening over the internet time to call in, I will quickly run through our public comment housekeeping. Remember, public comment is opportunity to discuss general matters that fall within the purview of Commerce and Labor. If your remarks are outside of that, I will ask you to redirect them or terminate them. The public has already been given time to support or oppose specific legislation, so therefore public comment is not intended to be a continuation of a bill hearing. We limit public comment to 30 minutes and 2 minutes per caller. I would remind everyone we do not make personal attacks. Please be respectful to members and other witnesses. And if you would like to submit your written remarks, we would strongly encourage you to do so for inclusion in the meeting record. Broadcasting. Do we have anyone on the line wishing to give public comment?
Chair, the public line is open and working, but there are no callers in the queue at this time.
Thank you so much. Any other comments from members on the committee? Okay, members, we will be meeting Friday. Please be on the lookout. We won't have any bill hearings that I know of, but we will be conducting a work session, so just be on the lookout for the agenda. And as always, please note the meeting start time. Thank you so much. We are adjourned.